This edition will deal with service of suit summons and notices by electronic media in India and outside India, and of courts outside India in India. Order 5 of the Code of Civil Procedure deals with issue and service of summons. The term summons is used in relation to a suit, and the term notice is used in relation to an interlocutory application in a suit. Where the proceeding is a petition, then the term used is notice and not summons. But the rules for issue and service are the same. I will in this podcast address the issue of whether suit summons and notices can be sent by electronic media. In our country, till recently, summons and notices were paid for by the plaintiff and delivered through the process of the court bailiff or post using the services of India Post. Order 5, Rule 9, Sub-Rule 3 has been amended to include fax messages or electronic mail service as provided by the rules made by the High Court. To my knowledge, in Karnataka, no rules have been framed. In Delhi, however, the rules provide that notwithstanding anything contained in Order 5, Rule 10, registered post acknowledgement due, speed post, authorized courier, electronic mail service, SMS with hyperlink if required, or any other web-based or virtual communication mode, or Dasti service, in addition to service of summons in the ordinary way, is permissible. The Supreme Court, in Central Electricity Regulatory Commission versus National Hydroelectric Power Corporation reported in 2010, NSCC 280, permitted service of notice by email along with the ordinary mode of serving notice. In Tata Sons Limited versus John Doe's, reported in CS Commercial 1601 of 2016, this was on the original side, the Delhi High Court permitted service to the defendant via WhatsApp text and email. It is to be kept in mind that claiming WhatsApp or email is not a matter of right. It still appears to be in the discretion of the court to grant the same along with the usual mode of service. Now, in the case of the need to serve summons abroad, the same is governed by the 1965 Hague Service Convention. India is a signatory to the Hague Convention on Service Abroad of judicial and extrajudicial documents in civil and commercial matters. The formal method for service in India with effect from 1/8/2007 is pursuant to the Hague Convention. Now, where a foreign court desires to serve somebody in India, according to this convention, for service in India, it must be in English. Documents cannot be served via email. Documents must be served in India indirectly via proper authority, and documents under the Hague Convention cannot be served directly to the defendants in India by private judicial officers. It would be useful for any of you listening to this podcast to go to the website of the Ministry of Law and Justice at lawmin.nic.in. As regards service of summons and notices and judicial processes issued by Indian courts, the guidelines issued by the Government of India, Ministry of Home Affairs, bearing number 25016/17/2017 Legal Cell, dated 11/2/2009, may be seen for complete details of the process. It appears that service of summons by email and other modes is not fully accepted because there are inherent limitations to proving service. Where, however, the summons is responded to by the recipient, there is no reason why this mode of service should not be accepted by the courts. The Ministry of Home Affairs, MHA, has entered into mutual legal treaty agreements with 22 countries which provide for serving these documents. These countries are Switzerland, Turkey, United Kingdom, Canada, Kazakhstan, UAE, Russia, Uzbekistan, Tajikistan, Ukraine, Mongolia, Thailand, France, Bahrain, South Korea, USA, Singapore, South Africa, Mauritius, Belarus, Kuwait, and Spain. In other cases, that is, for other countries, MHA makes a request on the basis of assurance of reciprocity. The difference between the two is that the Mutual Legal Treaty, or MLAT as it's called, countries have an obligation, whereas non-MLAT countries have no such obligation. The Ministry of Home Affairs forwards summons, warrants and judicial processes to the concerned Indian missions or embassies, which in turn take up the matter with the designated authority. In some countries, the job of service of judicial papers is entrusted to private companies or NGOs. All requests for service should be addressed to the Under Secretary Legal, IS2 Division, Ministry of Home Affairs, 9th floor, Loknayak Bhavan, New Delhi 110003. Please remember that the MHA requires at least 12 weeks for service, and the date of hearing should therefore be decided accordingly in the court which issues such judicial process.